Hi, my name is Rachel O'Kello and I'm a UK-based solicitor specialising in immigration, nationality and deportation law. And today I want to talk to you about deportation. Yesterday, as part of our summer series, which this is a video in our summer series, we talked about overstayers, and a lot of people asked me to speak about deportation. So that's what I'm going to talk about, criminal deportation. So if you don't have leave to remain in the United Kingdom, then you can be removed, and it's mostly called administrative removal. So you're not really being deported as such, but you're being administratively removed, and you can make an application to re-enter the United Kingdom if you have grounds to do so. However, deportation in the truest sense of the word happens after somebody has committed a criminal offence in the United Kingdom and they have a deportation order saying that their presence in the United Kingdom is no longer conducive to the public good and they are required to leave, and they will be forcibly removed if they do not go voluntarily. If you are a non-British national living in the United Kingdom, so you're not a British citizen, and you commit a criminal offence and go to prison for more than 12 months, you will be automatically liable to deportation proceedings. It's the same if you commit a series of offences as well. There are provisions within immigration law for somebody who commits a series of criminal offences, who's a repeat offender, to also be subject to a deportation order. But primarily, certainly if you go to prison, if you get a prison sentence for more than 12 months, the Home Office will write to you in prison and say that we are required to ask you why you should not be deported from the United Kingdom, even though you have committed a serious criminal offence. And a serious criminal offence will be defined as an offence where somebody has gone to prison for more than 12 months. If you go to prison for more than 4 years, you go into a category of being an even more serious offender. Okay, so anything between 12 months and 4 years, and you will be looking to rely on one of the exemptions against deportation. And the main one that people rely on would be they have a family and private life in the United Kingdom, the length of time that they've lived in the United Kingdom, and asylum. They will be looking to rely on those primarily. There's also people trafficking provisions, and there are mental health provisions in place for people who feel that they should not be removed from the United Kingdom back to their country of origin because they fall in under one of the exemptions to deportation. If you go to prison for more than 4 years, so you have a prison sentence of more than 4 years, then in addition to the showing that you should be exempt from deportation proceedings, you will need to show that you can use these exemptions or use other grounds against your deportation, because there are other very compelling reasons why you should not be deported. And those other very compelling reasons will be specific to your circumstances, and it is for you to convince the Home Office, and if it goes to court, a judge, what the other very compelling reasons are against your deportation. And you should bear in mind that neither the Home Office nor the court will have a sympathetic view towards you if they find that you've come to the United Kingdom, you've been given leave to remain, and effectively, in their eyes, and no judgment, but you've abused that leave to remain that you've had by committing an offence so serious that you've gone to prison for more than 12 months and in other cases more than 4 years. So we challenge deportation order cases. We challenge them before the deportation order is granted, and we challenge them after the deportation order is granted, whether somebody is still in the United Kingdom or whether they've been removed from the United Kingdom, trying to get that person back into the United Kingdom. But it is not easy at all. And my top tip is to stay away from being liable to deportation by not committing criminal offences if you've been in the United Kingdom at all, but particularly from an immigration point of view if you are not British, because you can be deported. And the Home Office don't care how long you've lived in the country. So you could have come here, you could be born here and not be British. They will still try to deport you if you commit offences as an adult. You can have lived here all your life, you can have a British accent, you could have gone to school here. They don't care. A lot of young people get perfectly shocked when the Home Office start deportation order proceedings against them, calling us up in their London or their Birmingham or their Manchester accent, saying they're subject to deportation proceedings. Well, the reality is the Home Office will actively seek to deport you if you are a non-British citizen who's gone to prison for more than 12 months. Okay, so if you want to discuss this further about your own case, you can contact us at our office on 0121 3894 895 or find us online at clarityvisas.co.uk. Take care, have a good day, and be good. Bye-bye.